It's time to move on to our next speaker, George Salmas. And George is going to be talking about dietary fiber, citizens petitions, class actions, and beyond. George?
Okay, the approach today for me is we're going to try to accomplish two things. The first thing is you folks are all scientists. And what I want to do today is help you visualize how what you're doing fits into the business side of the enterprise. Because a lot of times you'll be sitting in a meeting, I see this happen at the meetings that I attend, and you're not really briefed on how what you're doing plays into the big picture. So when I have a meeting, when I'm in charge of a meeting where there's scientists involved, I meet with them separately ahead of time and say, here's what we're trying to do, here's the issues, and put it all in focus. So that's one thing I want to do is on these dietary fiber, what's the big picture? Also, there'll be a few takeaways. And these are like specific facts that you probably ought to remember because they'll be important to you. And when a takeaway comes along, I'll say, this is a takeaway. There'll only be 3 or 4 of those. Most of what we're doing today is big picture stuff. All right, so topic number 1. When do the new regulations apply to my product? This is something, I hear a lot of discussion about this, and it's like Yogi Berra would say, 70% of what you hear is incorrect, and the other half is wrong. Everybody I hear talking about this just is incorrect, and so here's the answer. It applies to your product when you adopt the new labeling format. This is your takeaway. If you remember one thing from this discussion, this is the most important one. The new regulations will apply when you adopt the new labeling format to your product. Now, there's 2 plays here. One of them is if you produce a product and you're an end producer, and the other one is if you're an ingredient supplier. So I'm going to talk about both of those. All the products that you have out in the world on the shelf have to have the new labels on them by July 26, 2018. That's the compliance date. So some of the things that I hear that are wrong are someone has an existing product and they print new labels and they have a shelf life of 1 year or less. And they would rather not go to the new label format yet. They don't have to. You can print new labels as long as they're off the shelf because of the shelf life of your product. By July 26, 2018, you can print new labels under the old rules. Okay? The other one is people come out with new products, and they would rather have the product come out in the first go-around under the old rules. You can do that as long as all of your product is off the shelf by July 26, 2018, because that's the compliance date. That's the date by which your products on the shelf have to be under the new rules. So if you're a product producer, if you make the end product that goes on the shelf, you've got 100% control. You can change over to the new label when it's to your advantage, when you're ready to. And so I have clients where we've delayed changing over to the new labels because we have to do more work, more reformulation to be ready to go to the new rules. So we've stayed with the old labels longer. I have other clients who jumped to the new rules immediately because it gave them an advantage. And so that's one thing. If you're the end producer, that's a control that you have over how the rules apply to you. If you're an ingredient supplier, it's a little bit more tricky because you're going to be stuck with the date that your customers shift over to the new rules, because they're going to ask you for a specification statement, a specification sheet, or a COA that shows if they've shifted to the new label, they want a COA that aligns with the new rules. So it's trickier if you're an ingredient supplier. So what you do in that case is, if your ingredient is like the most important ingredient in their product, you can work with the supplier about when they're going to make the change, and you can have some control too. But if you're an ingredient supplier, it's a little bit more tricky. The next topic is qualifying your carbohydrate under the new rules. And this has already been talked about a lot, and I'm going to take a little bit of a different approach to it. I'm going to spend a little more time on how you play this game, the politics and the law involved in this. I think and this is what I do personally, and this is the way I persuade other people to do it if it's helpful to them, is I think of the new dietary fiber definition as two separate definitions, because it's like a fork in the road. You go down one fork or you go down the other, and you got to make the decision at the starting point, or you'll get forked, I guess is what I would say. All right, so the definition one, the key concept here is intrinsic and intact in plants. I think of these as chunks of plant, and you pretty much have to carry it over as a chunk of plant. The second part of the definition, or what I call definition two, is the isolated or synthetic fiber. This is the one where you started with a chunk of plant, but you did things to get the fiber to perform in the product the way you want it to perform. So as a result, you've taken out components of it. It's no longer intrinsic and intact. And so now it's isolated synthetic is what it's called, isolated or synthetic. And the point here is that these things are determined from a business standpoint differently. And this is what you got to be plugged into as the scientist, okay? And I will just tell you a quick story. One of the companies at this program hired our firm to do one of these analyses. And they wanted us to start both of them. And I knew that if I started both of them, I would get through 70% of one of them that wouldn't be needed. I could charge them for it. And that would be a ripoff. So I told them at the very start, hey, we only need to go down one road because I know where it's going to end. And if I'm wrong, all that work can be applied to the second road. But there's no need to start on both tracks at once. So this decisions point, and early on affects the bottom line of your company. Okay, so this is definition one. This is the one that I call the chunks of plant. The plant that you're keeping intrinsic and intact, okay? This determination of whether you qualify is made by the company. You make it internally. Now, the other definition two is different, and that's a very important difference to how you analyze these things. So, the company decides whether you qualify under this first definition. What if you get it wrong? Well, then you get to hire me to defend you. You may get an FDA warning letter, and our firm defends against FDA warning letters. But when you get an FDA warning letter, don't panic. There are things you can do to take care of yourself. I'll just leave it at that. Okay, the other thing that can happen is a class action for overstating your fiber. If you made the wrong decision early on and called it a dietary fiber and it isn't, you may get sued in a class action. This is not made up stuff. I defend food class actions. I've already defended successfully 3 of them on fiber being overstated on a label. If these people would have hired us at the start, they would have been much better off. I made a lot more money defending them and getting them out of a tough spot. So it's like an ounce of prevention is worth a couple $1 million a cure. So this can really happen. This is not made up stuff. If you want to make me happy, mess it up, hire me to defend you. It'll be great. But you don't want to do that. All right? So a class action for overstating fiber. All right, so how do you protect yourself? If you ask somebody inside your company whether or not this fiber qualifies as intrinsic and intact, the pressure on that person is going to be colossal to say yes. They don't want to say no because they know that's not the answer the company wants. The problem with taking that approach is that if you ever get an FDA warning letter or you get a class action lawsuit, you got nothing to stand on. All you got is some guy inside your company, and he'll be ripped to shreds. And that's not fair to you, and it's not fair to him or her as a scientist. So Dave came up with a suggestion of a GRASS-type panel, and then I put an attorney-client privilege twist on it. So here's how it works. If you've ever been involved in a self-GRASS affirmation, you know the way it's done is you bring in a bunch of outside experts, they do a study, and then you decide whether you can say your product is GRASS. And we've all been through that in one form or another. So what we decided to do to solve this problem about the company has to make the internal determination is it's a legal question. So they hire my law firm. So anything I tell them is attorney-client privileged. If you don't know, attorney-client privilege is like when the criminal talks to his lawyer, what's my story? That conversation cannot be heard by outside parties. But it applies to all conversations between outside counsel and a company. There's some exceptions. We won't go there. That's a whole other hour discussion. Bottom line is if your lawyer's giving you legal advice, it's privileged. Outsiders can't get it. If you get sued, they can't have it. It's private, okay? So then I hire the GRASS panel as my consultants because I'm entitled to do that as a lawyer, to hire experts to help me advise my client. And that's exactly what I'm doing. So I will hire 4 or 5 of the very best fiber guys in the world. One of them is sitting right here. And he's working on a panel with me right now, Dr. DeVries is, and he's doing a sensational job. Dave and I are working together on one also, on another one. So, my experts, who I have great respect for, otherwise I wouldn't hire them, they come up and they do the analysis on whether it's intrinsic and intact in plants. There's supposed to be a pointer here. There it is. Intrinsic and intact in plants. And they look at this whole definition, and they tell me what their opinion is of the facts. And as a lawyer, as a food lawyer, I apply the facts to the law, and I come up with a legal conclusion as to whether or not the product fits those criteria. Now, there's 2 possibilities, yes and no. If the answer is no, well, I tell the client that, and it's attorney-client privileged, and it never sees the light of day. Now, if the client goes back and changes the product, or we do more research, and then we get a different result, and now the answer is yes, as to that project, we can waive the privilege. I'll produce a legal opinion report, and you can give that to your customer. And your customer can be confident that what you have is intrinsic and intact because it's been decided by a blue ribbon panel and an attorney that spends all of his time doing these kinds of problems. And so now you've got something to stand on if the FDA has a question. You've got something to give your client or your customer, excuse me, if he's concerned about whether it's a fiber, and if you get the letter from the class action attorney, you send him a copy of the report, and you say, I got 5 of the best guys in the world on my side, bring it. And that'll be the end of that, because those class action attorneys that I oppose, they're looking for soft targets. And if you've already hardened your perimeter, they're going to go someplace else where the pickings are easier. So that's how you do the determination of whether it's intrinsic and intact, because you got to do it internally. Definition 2, this is the other one, where it's no longer a preserved chunk of plant. You've taken material and you've removed enough components from it, so it's no longer intrinsic and intact. Now it becomes the other fork in the road that I talked about. Now you're on the road, on the fork of the road, which is isolated and synthetic. All right? Now, who makes this decision? This is not an internal company decision. This one is determined via a citizen petition. What a citizen petition is, it's a legal document that is prepared, we prepare them, and you send it to the FDA, and you say, my carbohydrate qualifies as an isolated synthetic, blah, 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 okay? And you attach all the science to it. And then the FDA takes that and determines whether you're right or wrong. One of my clients is sitting here, Kimmo Lucas. We wrote the first dietary fiber petition. Did a great job, Kimmo. That was great teamwork. We filed the first petition that was ever filed with FDA on this topic. And we're still waiting for the result. I think it's going to be a while yet because the issue is still evolving. But what you do is, this is a legal document. I think ours is about 25 or 30 pages. Some of them are shorter, where you tell the FDA why you think you come in within this category. and then a bunch of FDA scientists look at it. Oh, by the way, I wrote these slides so that if you want to download them, it'll remind you what I'm saying. It'll be a refresher course on this stuff. So if you miss something, if you get the slides from the website, it'll help you. Here are two examples of fabulous citizen petitions. I wrote both of them, so I'm being modest. The first one is one that Kimmel and I did. Okay, and that one's on dietary fiber, all right? And we're still waiting for the result on that. 3 more have been filed. This one here is on allulose, on the calories in allulose. And I just want to say, you read some of these citizen petitions, and you just want to say, hit me in the head with a baseball bat. It's just boring, On the allulose one, the issue there is we're lowering the calories from 4 calories to 0.4. So I wanted to make it interesting. So I did some research, and I realized that First Lady Michelle Obama is on a child obesity, anti-obesity program. So we quoted her in our citizen petition to say to the FDA, this is something you should be interested in because it affects the national welfare. So it isn't enough to just put the science in front of the agency. They're busy enough. If there's some public policy reason why what you're doing is important to the people, then you ought to focus on that. And that's something that we spend time on when we prepare these kind of documents is this just purely a science question, or is it actually going to have some impact on somebody in the real world? So obviously, I don't want you writing down these links. Download the slides. You can click to the links and see what these documents look like. It's easy enough. That's why I put them in the slides, so when you download them, you can get to them real quickly. Otherwise, they're very hard to find. Okay, here's another thing. Do your homework. This is an internal memo from Dr. Trumbo to the FDA talking about how they're going to evaluate certain things involving dietary fiber. And this was listed as a reference in the new rule, but none of us could find it. We did every kind of possible search inside the FDA website, and we couldn't find this document, and a bunch of us did it, people that do regular literature searches. So my firm sent the FDA a Freedom of Information Act request. And unlike some of these things that have gone into the government recently and come back empty, the FDA was very cooperative. And after about, I would say 3 or 4 weeks, which is the speed of light, it really is. To do something like this, I'm trying to get even with the FDA, don't laugh. So we did a Freedom of Information Act request, and we got this document. And it's their internal thinking about how they evaluate some of these issues. And I'm sure that most of this stuff is going to end up in the guidance that Dr. Trumbo was talking about. So if you want a copy of this, give me your business card and just write FDA memo on it, and we'll email it to you for free. It's no big deal. It's a public document, even though I got it with a Freedom of Information Act request. Or if you want, just send us an email to our website. Our website is thefoodlawyers.com. Go to the website, send us a message that you want this internal FDA memo, and we'll email it to you. We're happy to do it. But the point here is you got to think outside the box. And so we went and got this memo to help do a better job for our clients. And it's a public document, so that's okay. There's already been talk about record keeping, and we know that there's new record keeping requirements under the rules. Here's all I want to say about record keeping. First of all, that is your information. Don't ever forget that. That belongs to you. Now, if the FDA asks for it, you obviously want to show it to them, but you want to mark it confidential, proprietary, or something like that, because it's going to contain information that you would not send to a competitor. The FDA is very good about protecting proprietary business information. So if there's something in there that you want to keep private, but the FDA asked for it, you want to be sure and mark it, like I said, proprietary or confidential. Now, you just can't mark everything on this side of the moon proprietary. It's got to have something in there that really applies to you. But if it does, that's a good way to protect your company from guys like me that might make a Freedom of Information Act request and try to get stuff that you don't want to have seen. So that's all I'm saying about record keeping. Okay, so a quick review of qualifying your carbohydrate as dietary fiber. Remember, the first definition was chunks of plant. Chunks of plant matter, intrinsic and intact. The company makes that determination internally, and the way that we think you should do it, the best way, the safest way to protect yourself and the public and get the right result is the grass-type panel. This doesn't appear anywhere in the regulations, but I think it's the best way to do it, and you protect yourself if you have it behind attorney-client privilege if you get a result that you don't like. And let me explain. I try food cases. Trial lawyers are bad guys. Sometimes I'm a bad guy. And if you have a bad study, and then you change things and you have a good study, well, what's going to happen is you're going to have the bad study thrown in your face by the bad guys. So that's why you want to keep the bad studies private. You want to learn from them, and then you want to improve yourself. But you don't want to come back later on and have them thrown in your face unfairly. So that's why we take that approach. It's to protect the company and to really protect the integrity of the system. Definition 2 was the one that is no longer a chunk of plant. This is the one, remember, where you've taken out so many components that now it's isolated or synthetic. And this is the one that is determined via the citizen petition that you file with the FDA. And the FDA makes the call. Okay, a final word about class actions. It can happen to you, all right? I know you read about these things and, somebody gets sued for a label infraction and, yeah, it's never going to happen to me. We just got hired by a bakery in the Midwest that had the same label for years and years and years, and they thought they were fine, and now they're involved in a federal class action, and we're defending them. So we're gonna be fine in that case because we already know how we're gonna play it. But the point is, if they would have had us up front and we could have done some preventive medicine, they would have sold just as much product, but they wouldn't have gotten involved in a class action. And it's just the reality. Some people some people can run the same stop sign every day and never get in a crash. Others run it one time and smack, they hit a truck. So that's the chance you're taking if you're not being careful with your labels on these issues. Okay, listen, you guys have been a terrific audience. Thank you so much. It's like boxing. Protect yourselves at all times. Thanks a lot.
Okay, thank you, George. We have come up to the time for the end of the session, but we certainly will welcome questions if anybody has any right now, wants to come forward.
I suppose this, Barry McCleary here. I suppose this question goes more to Paula than to you, George. But in terms of this business of obtaining a polysaccharide, you could take. I'm just wondering where the line's drawn. Say, for instance, you could take a seed like guar seed that has about 20% of galactomannan, a very good dietary fibre. You could wet it and mill it, and you get that dietary fibre value up to 40%. Where's the line drawn between that being intrinsic and being a component?
Hey, Dr. McCleary, it's great to meet you after reading about you and reading your stuff so much. So thank you, sir.
Thank you.
You've absolutely asked the perfect question. There's going to be some times when it's on the margin, when it's on the line, and I think in that situation you have to make a political decision, which is if we think we can get this in as an isolated fiber, if it meets those tests, that might be the safer approach. Because if we determine in good faith that it is intrinsic and intact, but it's so close to the line that you could have reasonable people disagree, then my advice would be go to the political side, file the petition, have FDA endorse it, and then we're going to be golden. And one thing we thought about this a lot was we're wondering if FDA is ever going to get a petition like that and say, no, we think it's intrinsic and intact. Well, if they did that, then you win that way.
Yeah.
But Doctor, I think the answer is if you're that close to the line, you probably have to go with the petition.
Thank you.
Let's thank our speakers again, and thank you all for attending. And everybody have a good day. Okay?